Thank you. That concludes topical questions. The next item of business is consideration of business motion 19228 in the name of Graham Day on behalf of the Parliamentary Bureau, setting out a timetable for the Stage 3 consideration of the Criminal Justice, Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill. I ask any member who wishes to speak to the motion to press the request to speak button, and I call on Graham Day to move the motion.
Moved, Presiding Officer.
Thank you, Minister. No members asked to speak to the motion. Therefore, the question is that motion 19228 be agreed. Are we all agreed? The motion is therefore agreed. The next item of business is Stage 3 proceedings for the Criminal Justice, Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, that is SP Bill 52A, the marshalled list and the groupings of amendments. The division bell will sound and proceedings will be suspended for around 5 minutes for the first division of the Stage 3. The period of voting for the first division will be 30 seconds, and thereafter I will allow a voting period of 1 minute for the first division after a debate. Members who wish to speak in the debate on any group of amendments should press their request to speak buttons or enter RTS in the chat as soon as possible after the group has been called. Members should now refer to the marshalled list of amendments. And we head to Group 1, virtual attendance. And I call Amendment 58 in the name of Pauline McNeill, grouped with Amendments 59, 2, 60 and 1. Pauline McNeill to move Amendment 58 and speak to all amendments in the group.
Thank you, Presiding Officer. Speaking to Amendment 58, 59, 2 and 60 on virtual attendance. Amendment 58. An official appointed by the Court will be in attendance with the person who is attended by electronic means. And B, it is satisfied that the electronic means of sufficient speed and quality to enable the person to see and hear all of the other parties and judge, where applicable, the jury and any witnesses giving evidence. So at Stage 2, the Cabinet Secretary said that having a court official in attendance would plan an unsustainable burden on court officials and would come with an unsustainable and unquantifiable cost. So I revised that amendment to say that an official appointed by the Court. It was a matter raised by witnesses that the giving evidence virtually should have the equivalence of a courtroom. And at one of the criminal justice sessions, Sheriff Principal told us that we would observe virtual hearings are heavily dependent on the adequate resourcing of technology and infrastructure. And the Faculty of Advocates told the committee these undoubted and important benefits do come at a cost to the justice system. The valuable court time is regularly lost due to delays in establishing remote links and re-establishing remote links. I also welcome the Amendment 2 in the name of the Cabinet Secretary, which relates to... Who did we... give me a minute. Including what requirements must be satisfied by the location from which the person is to appear. Before I ask the Cabinet Secretary if she wants to intervene, I would say that I'm clear of the importance of virtual attendance, and I'll not be moving it, but I just wanted to be... Oh, it's not the Cabinet Secretary. Who was it? Audrey Nicholl, sorry. Let me just finish my point. I'm in full support of the virtual attendance. I just want to make sure that one of the most important things, because I've witnessed it for myself, where there have been very poor connections to the point where we couldn't actually identify the accused. I know this is in hand, but it was an important issue to raise at Stage 3, who was not party to the conversation and debate prior to this. And I give way to the convener, Audrey Nicholl.
Audrey Nicholl.
Thank you to Pauline McNeill for giving way, and I note the rest of her contribution following my intervention. It was simply just to point out that I wasn't really clear under what circumstances the court would require an official to be present at a virtual hearing, i.e. with a witness or an accused. And I am aware that following Stage 2, as the member says, there was, perhaps Stage 1 actually, there was a significant amount of work, as I understand it, by the Scottish Government on this particular point. So hopefully some of that's been clarified.
Yes.
Thank
you for that helpful intervention, because I think that's what the crux of the matter is. Obviously, we want to make sure that when people give evidence, they're giving evidence in similar circumstances to giving evidence in court. I imagine that they would virtually give the oath as you would in court. And the reason for initially pursuing this question of a court official, which I've now amended, is that to me would be someone should check that there's no one in the room. Now, I'm sure the Cabinet Secretary will speak to this, because there should be no one in the room or no one who might influence someone giving evidence. And I wasn't sure how that would be done, if it was done in a virtual room. Now, I'm aware that Victim Support Scotland do have excellent suites where people can give evidence by commission. So I suppose it's just that not being a practitioner, it's the unfamiliarity with how this can be satisfactorily to everyone's conclusion that it has the same solemnity as giving evidence in court. And for the witnesses' point of view, we don't want witnesses to be giving their evidence, which otherwise they might not, for it to have the same value as a witness in court. And that's why I wanted to air it. And in that, Presiding Officer, I conclude.
Thank you. I call Cabinet Secretary to speak to Amendment 2 and other amendments in the group.
Thank you, Presiding Officer. Let me start with Ms McNeill's Amendment 59, as I am pleased to say that I can support this amendment. It appropriately addresses any concerns as to how the Lord Justice General exercises their determination-making power to disapply requirements for physical attendance. It is right that the rationale for those determinations is readily available and understood. And while I understand why Ms McNeill has raised the issues at stage 2 and stage 3 that she's referenced in her amendments 50 and 60, I do, however, have to say that I cannot support these, as they would be a backward step and would place unnecessary burdens on the court. Presiding Officer, the bill provides for virtual attendance in criminal proceedings by making permanent the legislative underpinning that has been in place since 2020. The provision has been used by courts to allow hundreds of police officers and other professional witnesses to give evidence remotely, instead of having to travel across the country to attend court in person, sometimes over several days. The time and resource that have been saved underscores the importance of this provision. Members will know that remote attendance was not a new concept brought in by the emergency coronavirus legislation in 2020, as forms of virtual attendance at court have been commonplace for decades. Ms McNeill's Amendment 58 would require an official appointed by the court to be in attendance with every person attending a trial virtually, and it is wholly unworkable in practice. Of course.
Martin Whitfield.
I'm very grateful to the Secretary of State for taking an intervention. Does she envisage limiting it, therefore, to, in effect, professional witnesses, police officer witnesses, where there's an assurance that there won't be interference in the evidence if it is given remotely?
Cabinet Secretary.
So, in terms of virtual attendance right now, it is mostly used by professional witnesses, police officers, doctors, and they will do that quite often from their place of work, where they work every day in a professional environment. In terms of vulnerable witnesses, where there is that opportunity to either have special measures or to give evidence remotely, there are evidence by commission suites where the government has invested money and there is a court official present at those facilities. And Ms McNeill has also mentioned the great facilities that Victim Support Scotland have in Edinburgh as well. And then for children, we have the Bairns House. Presiding Officer, Ms McNeill's Amendment 58 would require, as I said, an official appointed by the court to be in attendance with every person attending a trial virtually, and my concern is that that would be unworkable. Yes.
Polly McNeill.
Thank you. And it's helpful to clarify that where there's formalities of using the government-funded suites or victim support, then we already have satisfactory arrangements in place. But given the Lord President has the power under the permanent power under the Act, if passed, to allow virtual evidence if they weren't giving evidence in any of those conditions. I just wondered, that was my motivation. Who checks then that there's no one in the room and that everything is as it should be when that person gives evidence? And I don't know if you could answer that, but it would be helpful to know before we close this matter.
Cabinet Secretary.
So, in terms of professional witnesses, whether that's doctors, police officers, other experts, I'm not aware of the requirement to have someone with them on site. I would have the utmost confidence in police officers being able to give evidence to courts remotely. As I said, in terms of the Scottish Court and Tribunal Service, evidence by Commissioner suites, they're obviously overseen by the court service. And it is worth reminding Chamber that the default mode of attendance is physical. And there has only ever been one determination issued by the Lord Justice General, and that was in September 2022, for types of hearings where the default mode of attendance is virtual. And these are preliminary hearings, hearings that tend to be quite short, sentencing hearings where the person is detained, full committal hearings in sheriff courts when the person is detained, bail appeal hearings, and the determination also provided for people who were suspected of having COVID, of being advised to self-isolate and to attend virtually. So and overall, it is shorter, more procedural hearings, and the default position that people attend court in person, in particular for hearings where evidence is being led and trials, the expectation would be that would be in person, unless someone has been a vulnerable witness and they have had the pre-recorded opportunities. Presiding Officer, going back to the specifics of Amendment 58, this would place, in my view, an unsustainable burden on the courts and appointing officials to do this. And with significant costs and demands on resources it would bring, it would mean that virtual attendance would essentially become impracticable and we would lose all the benefits that it currently achieves. As I said in stage 2, when an almost identical amendment was debated, these provisions have been very effectively used to allow police and professional witnesses to give evidence remotely in High Court cases, often from their workplaces, and it would be wholly inappropriate to require officials appointed by the court to attend at those locations with such witnesses. On the requirement for the court to be satisfied with the electronic means of virtual attendance is of sufficient quality and speed, it's just not clear how the court could be meaningfully satisfied in each case, given the volume of witnesses attending from different locations, and it would be entirely impractical and problematic to place an obligation on the court to be satisfied as to the minimum technical requirements before the witness can give evidence remotely. In addition, these amendments are not future-proofed, meaning that as technology expands and improves in the years to come, courts would still be required to check on the speed and the quality of internet connections. Ms McNeill's Amendment 60 relates to information contained within the court's direction, setting out how a person is to attend proceedings virtually. This amendment would require individual directions in every single case to contain technical specifications that are, on the whole, out with the general expertise and role of sheriffs and High Court judges. And I am sure court users and indeed MSPs would expect judges would not expect judges to routinely spend their time setting out minimum broadband speeds in open court. So I therefore do not support Amendments 50 and 60, which would do nothing to improve the practice of virtual attendance or the experience of the court users. However, To provide reassurance on this very issue, though, the bill already provides that if a direction is being given out on virtual attendance, then it must require the witnesses to use means that enable all of the other parties, the judge and, where applicable, the jury, to both see and hear the witness. It is not necessary to place an additional burden for technical specifications over and above that. In addition, my Amendment 2 requires a court, when issuing a direction detailing how a person is to attend virtually, to set out what requirements must be satisfied by the location from which the person is to appear. The purpose of this amendment is to enable the court to set parameters around what makes a location suitable for virtual attendance, and this would guarantee that the provision can continue to afford flexibility to police and professional witnesses, while also ensuring that remote evidence continues to be delivered in a way that is consistent with the solemnity and integrity of court proceedings. This amendment would enable a court to issue standard requirements in every direction, for instance stating that a person must attend in a private place with minimal distractions using a stable internet connection. I believe this approach better meets the concerns of members than requiring rigidity in locations or technical requirements. Presiding Officer, I am pleased to have been able to work with Liam Kerr on Amendment 1 regarding reporting on the use of virtual attendance in court proceedings. This report will provide important evidence to the effectiveness of this provision in delivering benefits to all users in the justice system. And I ask members to support Amendments 1, 2 and 59 in this group and oppose 58 and 60.
And I call Liam Kerr to speak to Amendment 1 and other amendments in the group.
Thank you, Presiding Officer. At stage 2 of this bill, I lodged an amendment that would have required the Scottish Government to publish a report on the use of virtual attendance in court proceedings. Because whilst the provisions for virtual attendance have been in place for years, there is, in my view, a dearth of data about its operation. And it seemed to me that by publishing a report, stakeholders could better understand the extent to which virtual attendance is delivering greater efficiency and effectiveness. Now, at stage 2, I proposed the amendment, but conceded during the debate that it wasn't quite right as drafted, so I didn't press it. Amendment 1 is the new and improved request for this report, and I should have put on record early that I'm grateful to the Government for its approach to working with me on this and what has now become a handout amendment. So if passed, Amendment 1 places a requirement on the Scottish Ministers to undertake a review of the way in which virtual attendance provisions in sections 303G to 303M of the Criminal Procedure Scotland Act 1995, as inserted by Section 2 of this bill, will operate over the 2 years from when that Section 2 comes into force. Now, when undertaking this review, Scottish Ministers will also be required to consult stakeholders, such as, amongst others, the Chief Constable, the Law Society of Scotland, of which I remind the Chamber I am a current member and practising solicitor, and the Faculty of Advocates. So that is to say, the views of those who use this provision the most will be considered and included as part of this review. And the amendment requires that as soon as reasonably practicable after the review has been completed, the Scottish Ministers prepare a report on the review, publish it and lay a copy before the Scottish Parliament. So I think this is a very positive step, and I think it's a step which will assist all stakeholders going forward, and therefore I'm pleased to move that amendment in my name. As regards the other amendments in the group, I find myself persuaded by Pauline McNeill's Amendment 59 and similarly the Cabinet Secretary's Amendment 2. Both of those I think are useful, and the Scottish Conservatives will vote for them. However, I am unpersuaded by Pauline McNeill's Amendments 58 and 60. Very briefly, I have significant concerns, as I shall outline later, as to the burden, particularly financial, that we as a Parliament are placing on what is an already stretched justice system. And I think the Cabinet Secretary's concerns on this, on Amendment 58 and 60, are therefore well-founded, and thus, if pressed, I won't be voting for Amendments 58 and 60. Thank you.
Thank you. And I call Pauline McNeill to wind up and press or withdraw Amendment 58.
Thank you very much. I start by reassuring the Cabinet Secretary and Liam Kerr that I don't intend to press 58 and 60. I just felt we needed to flush out some of the issues, which I think the Government and Liam Kerr have actually brought forward, which I think is really helpful. I mean, the Government's Amendment 2, I think is what I was really trying to achieve, so I'm really delighted to support that. I'm also pleased that the Government are going to support Amendment 59, where the Lord President sets out the powers, using the powers will set out the rationale for using it. I'm also welcome what the Cabinet Secretary said earlier about the use of this power. I mean, that's really what I think is the important part to debate. The default will be physical. But to allow vulnerable witnesses and maybe people who are ill at that time, we need the flexibility for them to attend virtually, and we know that it works. All I'm certainly trying to achieve here is to make sure that when we're legislators, not practitioners, that we've closed every gap that there could be. Just lastly, on the question of the Cabinet Secretary is quite right to see that it's quite hard to who would test whether the connection is good enough. But as I've said many times in this debate, I have sat through a custody court where the sheriff literally asked me to come to chambers and say, look, this is what I've got to put up with. You know, it's just an appalling quality. So that's where it was coming from. So I'm reassured by what the Scottish Court Tribunal has also said around that's obviously work in progress. But we've got to make sure as the Parliament that we reach that point where it's satisfactory. We know that technology is capable of it. We just need to make sure that it happens. On that basis, Presiding Officer, I will be moving Amendment 59 and I will not be moving Amendment 58 and 60 when asked.
Thank you. To confirm, Polly McNeill seeks to withdraw amendment number 58. Does any member object? No member objects and the amendment is withdrawn. I call Amendment 59 in the name of Pauline McNeill, already debated with Amendment 58. Pauline McNeill, to move or not move?
Moved.
Thank you. And the question is that Amendment 59 be agreed to. Are we all agreed?
Yes.
We are agreed. I call Amendment 2 in the name of the Cabinet Secretary, already debated with Amendment 58. Cabinet Secretary, to move formally.
Moved.
Thank you. And the question is that Amendment 2 be agreed to. Are we all agreed?
Yes.
We are agreed. I call Amendment 60 in the name of Pauline McNeill, already debated with Amendment 58. Pauline McNeill, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call Amendment 1 in the name of Liam Kerr, already debated with Amendment 58. Liam Kerr, to move or not move?
Moved.
Thank you. The question is that Amendment 1 be agreed to. Are we all agreed?
Yes.
We are agreed. We move on to Group 2, Digital Productions. I call Amendment 61 in the name of Pauline McNeill, grouped with Amendments 62, 63 and 3. Pauline McNeill, to move Amendment 61 and speak to all amendments in the group.
Thank you, Presiding Officer. Amendment 61 says that where an image of physical evidence is treated in criminal proceedings as if it were the physical evidence itself, either party in the proceedings may request the physical item be produced in court. It also says where a request is made under Section 1ZA before or during the trial, the physical item must be produced in court. Amendment 62 says, notwithstanding any direction made under this section, where either party in the proceedings requests the physical evidence to be produced in court, the request must be granted. First of all, I want to say what it is I was trying to achieve here, because there was quite a bit of debate at Stage 1 and Stage 2 about digital productions. Now, I totally support the principle behind this, that in many cases there's no requirement for to have a physical item in court, and a lot of time and money and space could be saved. So I'm in favour of that. Before we close on this, I just wanted to make sure that we retain to some degree the status quo, and the status quo being where there are cases, and I don't know how many cases there would be, where having the physical item in court for the jury to see it could be really important. Now, I know that the way that the bill is structured, that doesn't prevent that, so that the parties would be required to see in advance, I want the item in court, and if they don't do that by the time limits, then they can then go to the court and ask the judge if they could have this item submitted to court. Both Amendments 61 and 62 ensure that either party can ask for the physical evidence to be produced I suppose what it boils down to is I didn't want there to be any time bar on it because we already operate on the principle that the item was in court, and there's a minor issue that it's possible that the court could say no. You might think, well, why would the judge ever say no? You can't have the item in court. I've also had the chance to talk to the Law Society and some members of the Faculty of Advocates or practitioners. They seem pretty satisfied that, I suppose, they're just looking for assurances that the government will continue to discuss the guidance with them as to how this will operate in practice. At stage 2, the Cabinet Secretary said that there is a common law right for the defence to examine any physical item whose condition is critical to the case against the accused, even though it will not be produced in trial. And I did find that reassuring. But I thought in the interest of justice we should tease out whether or not we've got it right. I just conclude by saying that, I did use this as an example of a case where a replica gun, which I've not witnessed myself, but for those who have, it's really important that the jury would see that a replica gun looks like a real gun, and that's obviously a criminal matter. So there are clearly cases where it would be beneficial, I would argue, for the jury to actually see the item. And of course, it is possible to produce the item. I suppose it would make sense to have some kind of tick box exercise in advance of the trial to make sure that there's a prompt to ensure that if the physical item is required, then you can do so. So I don't intend to move that amendment, but I just wanted to make sure that we'd properly examined that, and see Audrey Nicholl wishes to intervene. I'll be delighted to take an intervention.
Audrey Nicholl.
I thank Pauline McNeill for giving me. I hear what the member's contribution on this particular amendment. It was simply to point out the significant implications this would also have for Police Scotland, and obviously the member may recall they communicated this to the committee some time back, but Police Scotland have a significant role in the management of productions once they've been taken possession of. So it was just to flag this significant burden that this would place on them.
Pauline McNeill.
This relates to the retention of evidence. And again, my motivation was to try and maintain this. I wasn't trying to put any more responsibility or burden on police to retain any evidence they don't already. But it's just not being practitioners. We have to examine and make sure that there is no loss in the justice process by destroying evidence or not having it stored. When you think about some cases, the justice process can be a long one. So I can assure you and Police Scotland that I don't intend to move that one, but I did feel that we should be absolutely clear before we close on this bill that the important difference between producing the item and storing the item, and that there would be no loss to the interests of justice to pass it in this bill. Thank you.
Thank you. Call the Cabinet Secretary to speak to Amendment 3 and other amendments in the group.
Presiding Officer, this bill aims to increase the use of modern technology in our courts through a number of measures, including permitting the use of images in lieu of physical productions. And as we've heard, these practices are already happening. However, not only would such opportunities for modernisation be lost if Ms McNeill's amendments were agreed to, their effect would actually represent a step backwards in how evidence is retained, although I note Ms McNeill's remarks about her intentions. And I do acknowledge that it is important that each and every matter is discussed and debated to the satisfaction of members. In terms of the specifics, Ms McNeill's Amendment 61 undoes Stage 2 amendments unanimously agreed to by the committee, which set out the process and timescale by which parties can apply to the court for a direction, providing that an image cannot be used in place of physical evidence. That process gives the power to the court to determine if using the image in lieu of physical evidence would prejudice the fairness of the proceedings. Amendment 61 replaces this process with an oversimplified mechanism that would give parties an unqualified right to have items produced when they request it, with no role for the court to decide if that was necessary to avoid prejudicing the fairness of proceedings. And Amendment 62 would mean the court would be required to grant every request that is made for physical evidence to be produced at any point before or during the trial, removing any judicial discretion to consider what is fair. Compelling the court to grant every request in every circumstance would ultimately favour the use of physical productions instead of images. If the party leading the evidence is concerned that the other party could unilaterally require a physical item to be produced without any court consideration, they may simply choose not to use images in lieu of productions to begin with, and the use of physical productions would therefore remain the default. Presiding Officer, these amendments would therefore defeat the purpose of the bill, which is to support the greater use of digital productions. The bill already ensures that parties can request for physical productions to be used, and such productions will have to be produced where the court issues a direction. Ms McNeill's Amendment 63 is similar to amendments lodged at Stage 2, and I will reiterate the points I made then. Prosecutors have always been able to determine which productions need to be retained and for how long. There are obviously fundamentally different factors to take into account in relation to, for example, marijuana plants and drug offences, personal items belonging to victims and witnesses, and alleged murder weapons, and the bill will not alter the nature of those operational decisions. However, Presiding Officer, my major concern with Amendment 63 is that where images are used, physical evidence would need to be retained for much longer than if it had been used as the production itself. It is already common practice for some evidence to be returned or destroyed prior to the conclusion of a trial, and if Ms McNeill's amendments were agreed today, that could no longer happen. This would be unworkable and expensive for justice partners who would have to store items for longer. They also represent a regressive approach to retention that is not necessary and would be to the detriment of victims, their families and witnesses. So, for example, when a vehicle is involved in an accident, a photograph is taken of the damage for use at trial, and this amendment would mean that the vehicle would still need to be retained. Dangerous and hazardous substances that are now able to be destroyed would, under Ms McNeill's proposals, also need to be retained, even where no objection had been taken to the use of images. At present, when evidence is the property of victims or witnesses, the items can be returned with a label or image used in their place during proceedings. If these amendments are agreed, then the victim's property would not be returned until a considerable time after the trial had concluded. This could be personal items that are of value both in sentiment and cost, or items that a victim has to do without for more time than is necessary, and this is a distress that could just be avoided. And more harrowingly, victims' remains would also need to be kept and not returned to families. In her role as Head of Prosecutions, the Lord Advocate is uniquely placed to comment on the implications of this proposal on her staff and the wider system, and the Lord Advocate shared her views in recent correspondence with me, which she has allowed me to quote from. Any amendment which required the retention of physical productions to the stage of appeal would be catastrophic in terms of resourcing impacts across the system. Further, it would have the potential to lead to significant unintended consequences in relation to the return of property to its owner. In particular, I am concerned about the potential for an accused to manipulate the system to perpetuate control over a victim's property. In the context of domestic abuse and sexual offending, property can include intimate images and recordings where retention may be deeply distressing to victims. Police Scotland has also written to the convener of the Criminal Justice Committee highlighting the impact of the amendment on their operations and significant issues this would create for their estate and capacity to store physical evidence. However, Presiding Officer, at Stage 2 I recognised that members of the Criminal Justice Committee expressed a desire to see clarity in legislation about the impact of this provision on the use and retention of physical evidence. And my Amendment 3 responds to that. It would require the Lord Advocate to prepare and publish guidance setting out factors that prosecutors will take into account when deciding whether to use images in place of physical evidence, and the approach of prosecutors to the physical evidence itself where such images are used. This amendment has the support of Police Scotland, who manage the large quantity of physical productions, and will continue to work with the Crown Office to agree operational approaches to the retention of physical evidence. Presiding Officer, I urge Parliament to support my amendment and oppose those of Ms McNeill if pressed.
Thank you. And I call on Pauline McNeill to wind up and press or withdraw Amendment 61.
Nothing further to add, Presiding Officer, but I seek withdrawal of Amendment 61.
Thank you, Ms McNeill. Ms McNeill seeks to withdraw Amendment number 61. Does any member object? No member objects and the amendment is withdrawn. I call Amendment 62 in the name of Pauline McNeill, already debated with Amendment 61. Pauline McNeill, to move or not move?
Not moved.
The amendment is not moved. I call Amendment 63 in the name of Pauline McNeill, already debated with Amendment 61. Pauline McNeill, to move or not move?
Not moved.
The amendment is not moved. I call Amendment 3 in the name of the Cabinet Secretary, already debated with Amendment 61. Cabinet Secretary, to move formally.
Moved.
Thank you. The question is that Amendment 3 be agreed to. Are we all agreed? We are agreed, and we move to Group 3, National Jurisdiction. And I call Amendment 4 in the name of the Cabinet Secretary, grouped with Amendments 5, 6, 7, 8, 64 and 65. Cabinet Secretary to move Amendment 4 and speak to all amendments in the group.
Presiding Officer, let me start with my own amendments in this group. The Criminal Justice Committee has given careful scrutiny to the provisions of the bill concerning national custody jurisdiction. The committee's views were instrumental in the further refinement through Stage 2 amendments to make the end point of national jurisdiction clearer on the face of the bill, underlining that trials cannot be heard under national jurisdiction. Following Stage 2, Justice Partners raised a further issue around the capacity of these provisions to support the court's resilience when dealing with time-critical solemn custody appearances in emergency situations. This was prompted by the experience of the courts during the disruption caused by the storm Éowyn. When an accused person has first appeared on petition from custody and, after being committed for further examination, has been remanded in custody by the court, rules require that the accused must again appear in court within 8 days for what is commonly known as the full committal hearing. It is at this hearing that the court can be asked to authorise the accused's continued remand while prosecutors take the necessary time to prepare and serve an indictment on which the accused may ultimately face trial. Under existing provisions, if the accused's first appearance was heard by the court in the sheriffdom in which the offence is alleged to have occurred, the accused must also appear at that court for their full committal hearing. Alternatively, if the accused's first appearance was in a court sitting with national jurisdiction, the accused's full committal can be heard either under national jurisdiction or by the court. Presiding Officer, during Storm Éowyn, several courts were closed because of red weather warnings, and when making arrangements to have essential business dealt with by courts that remained opening, Justice Partners were limited in how they could use the national jurisdiction provisions, where the initial appearance on petition was not also heard under national jurisdiction. There was therefore a constraint on the ability of courts out with red weather warning areas to be able to assist with time-critical custody appearances from courts within red weather warning areas. I have lodged Amendments 4 to 8 that seek to address this issue by outlining a very narrow set of circumstances where an accused committed for further examination under local jurisdiction can have their next hearing take place under national jurisdiction. Those circumstances are where the court that heard the initial appearance is closed because of an emergency or special circumstances, such as adverse weather events like Storm Eowyn. I would stress that this provision is restricted to proceedings on petition, so will not enable hearings on indictment such as first diets or trial hearings to take place at a court with national jurisdiction. Presiding Officer, I do not support Katie Clark's amendments 64 and 65 because they are unnecessary. The proposals on the national jurisdiction in this bill have been consulted upon and scrutinised by Parliament, not just through this bill but also through the passage of the temporary coronavirus legislation and the subsequent extension regulations. Sheriffs have not raised any issues regarding access to sufficient information to allow national jurisdiction to operate effectively over the past 5 years that it has been operating. If background or other reports are required by the Sheriff in order to be able to deal with the case, the Sheriff will request those. Alternatively, if for whatever reason the Sheriff feels it is required, the Sheriff can also return the case to the local court for whatever further proceedings or consideration they deem to be necessary. I also have a concern that the amendments refer to the Sheriff requesting information from the court where the accused resides. This court would not necessarily be the local court that would have jurisdiction over any complaint or indictment, as jurisdiction follows the locus of the offence, not the residency of the accused, so the information would not be available. As such, if the information sought by the Sheriff concerned the accused's previous offending or was about whether there is a particular problem in a localised area, this amendment would not be guaranteed to assist, as the local court where the offending is alleged to have occurred may not be in the sheriffdom where the accused lives. However, to come back to where I started, Presiding Officer, all of this information is already available to sheriffs through the material they have or existing avenues they can access. Therefore, the addition of these provisions would only add unnecessary confusion to an established process that is working in practice. Presiding Officer, the purpose of national jurisdiction, which has been working well for 5 years now, is to ensure that custody hearings can be dealt with swiftly. I strengthened provision at stage 2 to address concerns over the ability of courts sitting with national jurisdiction to sentence in summary cases following an accused's failure to appear after trial. National jurisdiction does not undermine the principle of local justice, which is an important part of our justice system. It enhances the existing framework for dealing with custody hearings, and it remains the case that national jurisdiction cannot extend to trial hearings. And I ask members to support my amendments, which provide a proportionate solution to a practical issue raised by justice agencies, and to reject other amendments in this group which are unnecessary. And I move Amendment 4.
Thank you, Cabinet Secretary. I call on Katie Clark to speak to Amendment 64 and other amendments in the group. Ms Clark.
Thank you, Presiding Officer. I speak to my amendments 64 and 65. This bill allows national jurisdiction in custody cases and for individuals to appear from custody away from their local area and the part of the country where the alleged offence took place. In previous stages, concerns have been raised about the loss of the judge's local knowledge of a community or accused, and these issues were raised by the Law Society of Scotland and the Criminal Justice Committee of the Sheriffs and Summary Sheriffs Association. Although I note that the Cabinet Secretary has indicated today that these issues have not been raised during the time that the emergency legislation has been in place. My amendments encourage communication with the local court in national jurisdiction cases. I wouldn't be intending to press them to the vote today, but I have noted very carefully what the Cabinet Secretary has said, and I would hope that in the operation of this legislation, maximum communication would be encouraged to ensure that the interests of justice are served.
Thank you, Ms Clark. Cabinet Secretary, to wind up.
Nothing further to add.
Thank you. The question is that Amendment 4 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendments 5, 6, 7 and 8, all in the name of the Cabinet Secretary, all previously debated with Amendment 4. I invite the Cabinet Secretary to move Amendments 5 to 8 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 5 to 8? No member objects. The question is therefore that Amendments 5 to 8 be agreed to. Are we all agreed? Parliament is agreed. I call Amendment 64 in the name of Katie Clark, already debated with Amendment 4. Katie Clark to move or not move? That is not moved. I call Amendment 65 in the name of Katie Clark, already debated with Amendment 4. Katie Clark to move or not move?
Not moved.
Again, that amendment is not moved, which takes us to Group 4, Amendment of Indictment. Call Amendment 9 in the name of the Cabinet Secretary and a group of its own. Cabinet Secretary to move and speak to Amendment 9.
Presiding Officer, Part 1 of this bill seeks to modernise and enhance practice and procedure in the criminal courts to ensure that we have a justice system that is more efficient and responsive to current demands. Amendment 9 builds on that purpose and introduces a new mechanism to allow, in certain circumstances, prosecutors to seek to amend indictments to add additional charges against the accused. I set out in some detail the rationale behind this amendment in correspondence to the Criminal Justice Committee last week and why it would bring important benefits to victims, witnesses and the accused. Currently, once an indictment has been served, prosecutors cannot add substantive new changes to the indictment other than those relating to the accused's breach of bail or failure to appear at court. However, there are other circumstances where prosecutors may want to add further changes to an indictment after it has been served. Sometimes a complainer discloses further offending by the accused at a later date. We know that in abuse cases, disclosures can be staggered and delayed, and it can take complainers some time to be able to disclose the full extent of the abuse they have suffered. Another circumstance is where additional complainers come forward after the indictment has been served. This can sometimes be triggered by awareness or publicity following the accused's first appearance on the indictment, as the court proceedings on the petition prior to this stage are held in private and cannot be reported in any details. When such circumstances arise, prosecutors currently have two options for how to proceed. First, they could seek to desert the current indictment and serve a fresh indictment on the accused that includes a new charge. This would result in the trial diet fixed for the original indictment being lost and may also require an extension of the relevant time bars. This option can cause disruption, uncertainty and delay for victims, witnesses and the accused who may be on remand. The second option is to allow the existing indictment to proceed to trial and conclude without disruption, and to separately indict the accused a second time for a second trial on the additional charge. Where more of the doctrine of mutual corroboration is relied upon, this may mean that one or more of the complainers from the first trial will have to give evidence again the second time as a docket witness. That second trial could be a considerable time after the first, and in some circumstances the accused may be remanded for longer. As a result, victims, witnesses and the accused will have to endure two trials and many more months of being involved in the criminal justice processes before matters are finally concluded. Both of these options would result in significant duplication of resources and effort, as well as causing considerable distress and disruption for those involved. Presiding Officer, my Amendment 9 would provide prosecutors with a third option by introducing a new procedure to allow them to amend the existing indictment with the addition of new charges. This would allow all of the allegations against an accused to be tried together and preserve any trial diet that has been fixed to avoid delay for everyone involved where certain conditions are met. The first condition is that the new charges must relate to conduct that was not known and could not reasonably have been known by the prosecutor at time of service of the indictment. This is an important safeguard that ensures that this mechanism is used only in specific circumstances and does not undermine the existing time limits that apply to prosecutors in preparing their case after an accused appears on petition. The second condition is that the application is made as soon as reasonably practicable, after the prosecutor becomes aware of the conduct, and at least 2 months before the date of any trial diet has been fixed. This ensures sufficient notice is provided to the accused and is central to ensuring that, where possible, trial diets can be preserved. However, of course.
I'm very grateful. The amendment seems eminently sensible in my view, but there have been concerns raised around a potential impact on disclosure, specifically whether, if the duty to disclose only applies from the point at which the amendment to the indictment is allowed, the defence's ability to challenge that amendment might be curtailed, as well as, of course, preventing or limiting preparation time for trial. How does the Cabinet Secretary respond to that challenge?
Cabinet Secretary.
Presiding Officer, I think it's imperative, and I share the views that we have to make sure that all parties, and that includes the defence, that they have enough time to prepare. And the purpose of this new provision is to preserve trial diets where possible, and that can only be done if all parties have sufficient time to prepare. And that is why we require applications to ordinarily be made at least 2 months before a trial. And we've also included a further safeguard in allowing the court to grant an adjournment to the accused where that is needed. And I won't repeat my earlier remarks about the 2 conditions that have to be met before an application by the prosecution can be granted. But the operation of these conditions are there to help to protect an accused's interest, including ensuring that prosecutors act as swiftly as possible so that the defence can effectively prepare. And the practical effect of the conditions is that in each application the prosecutor will have to satisfy the court that they are met, and any information that is given in support of their application or requested by the court in that regard will be available to the defence, and that they will be able to request further information should that be required to consider their position on the application. And I appreciate that was a long answer in response to a question on disclosure.
Thank you, Cabinet Secretary. No other members have asked to speak. Is there anything you want to add by way of wind-up?
Just a wee bit, Presiding Officer, if you can just bear with me. If I can pick up where I left off, just to state that I do recognise that there may be circumstances that arise after the 2-month deadline, and therefore that's why provision is made that the court may consider an application made after this point on special cause shown. And the amendment further provides that unless the application is consented to by the accused, parties will have an opportunity to make representations regarding it. Where the court considers that these conditions are fulfilled, it must grant the application unless it considers there is just cause not to. In conclusion, it is important, Presiding Officer, that this provision does not give the Crown any new ability to prosecute accused persons for offences where it otherwise could not. It is about modernising the way in which the Crown is able to bring about those prosecutions, streamlining procedure and ensuring a more trauma-informed approach. And it would reduce churn in the court system by preserving the trial diet and avoiding delays. And I am grateful to justice partners who have been involved in the development of this amendment. We have engaged widely, whether it's the Crown Office, Scottish Courts and Tribunal Service, the Law Society of Scotland, Faculty of Advocates and the Scottish Solicitors Bar Association, and of course victim support organisations. And I am pleased that the amendment has broad support, and on that basis I would urge Parliament to take the opportunity the bill provides us with to advance this new trauma-informed solution to an existing issue and to support my amendment, and I move Amendment 9.
Thank you, Cabinet Secretary. Apologies for cutting you off short there. The question is that Amendment 9 be agreed to. Are we all agreed? Yes. Parliament is agreed. We come to Group 5. Part 2 reviews, and I call Amendment 10 in the name of the Cabinet Secretary, group with amendments as shown in the groupings. Cabinet Secretary to move Amendment 10 and speak to all other amendments in the group.
Presiding Officer, the amendments in this group and groups to follow relate to Part 2 of the bill, covering domestic homicide and suicide reviews. Amendments 10, 11, 12 make a number of changes to Section 11(3) of the bill, which lists those who can nominate individuals to be a member of the Review Oversight Committee. The amendments are reflective of our continued engagement to ensure that we have the correct representation on the Review Oversight Committee for domestic homicide and suicide reviews. Amendment 10 adds the Risk Management Authority to the list of nominating bodies, reflecting feedback from the testing of the review model, where stakeholders said that the Risk Management Authority should be included as their focus is to reduce the risk of serious harm posed by violent and sexual offending. Amendment 12 will remove the Scottish Social Services Council, the SSSC, as a nominating body because we agree that it is not the right organisation to represent social work on the committee. Its regulatory focus is on social work, workforce standards, rather than on supporting and improving social policy and practice. To ensure there is no gap created in relation to social work representation, Amendment 11 adds Social Work Scotland to the list of nominating bodies. This will ensure a more appropriate social work representative on the Oversight Committee, given Social Work Scotland's focus on supporting and improving the social work workforce policy and practice. The inclusion has been endorsed by COSLA, and I consider this amendment will strengthen the committee's ability to translate learning from reviews into improvement in social work service, something which I am sure we can all agree on and welcome. Presiding Officer, Amendments 30 and 31 add the Risk Management Authority and Social Work Scotland to the list in Section 25 to extend the duty to cooperate to them. This ensures consistency and effectiveness of the operation of the review model. Presiding Officer, as Social Work Scotland is not a public authority, further amendments are necessary. Amendments 22, 23, 25, 26, 28, 32, 33, 36 and 37 are necessary changes required in recognition of the addition to Social Work Scotland within the bill. As such, Section 20 needs to be broadened beyond public authorities. The term designated core participant is being used to convey that the organisations to which the duty applies are all key to the successful conduct of reviews. Presiding Officer, Amendments 54 and 55 would add the Risk Management Authority and the Scottish Social Services Council to the list in paragraph 3(1) of the schedule, so that an individual may not be appointed to hold a relevant office under the review model if the individual is, or within the year preceding the date on which the appointment is to take effect, has been a member, employee or appointee of these bodies. This approach will ensure that those taking up the role of the Review Oversight Committee Chair, Deputy Chair or a Case Review Panel Chair are independent, a key point raised by stakeholders through the work to develop the review model. This approach is consistent with the other bodies currently covered by this provision within the bill. Similarly, Amendment 56 relates to the addition of Social Work Scotland to paragraph 3 of the schedule, but in that case it is about having been a director rather than a member, which reflects the structure of Social Work Scotland. These amendments follow further engagement on the criteria of appointment to an office related to the review process and fundamentally to ensure there remains no conflict of interest. Presiding Officer, Amendments 57 and 52 introduce an enabling power which would enable the Scottish Ministers to modify the criteria where necessary and evidence for disqualification from appointment to a position related to domestic homicide suicide review model. This power is aligned with and will complement the existing powers to vary lists of persons in sections 11(5) and 26. It will, for example, allow an organisation to be added to the list in the schedule to reflect that organisations also been added to the list in section 11(3) and therefore avoid a potential conflict of interest. It will also allow changes to be made if, for example, Social Work Scotland, which is a non-statutory body, changes its name. Any regulations would be made using the negative procedure, which is in line with the powers mentioned above. The Delegated Powers and Law Reform Committee indicated they were content with this at stage 2 in relation to existing comparable powers. Presiding Officer, I move Amendment 10.
Thank you, Cabinet Secretary. No other members have asked to speak. Anything else you wish to add?
No, thank you.
The question is that Amendment 10 be agreed to. Are we all agreed? Yes. That is agreed. I call Amendment 11 in the name of the Cabinet Secretary. Already debated with Amendment 10. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 11 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 12 in the name of the Cabinet Secretary. Already debated with Amendment 10. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 12 be agreed to. Are we all agreed? Yes. That is agreed. It takes us to Group 6, Part 2 reviews, SIFT decisions, reasons and reconsiderations. I call Amendment 13 in the name of the Cabinet Secretary. Group with Amendments 17, 18 and 46. Cabinet Secretary to move Amendment 13 and speak to all other amendments in the group.
Presiding Officer, my amendments 18 and 13 ensure the Review Oversight Committee is able to reconsider a death where it previously determined that a review would not be undertaken in circumstances where new information is made available. Ministers would also be able to do likewise where they had been asked by the committee to take the original decision. The benefits of these amendments will be through introducing flexibility into the review process and the ability to ensure that cases can be reconsidered where further relevant information emerges after an initial decision not to hold a review. This will ensure we are putting victims and their families at the very core of the review model. The same process detailed at section 16 of the bill in relation to the initial determination as to whether to hold a review would be applied. That means the Scottish Minister's advice would still be able to be sought by the Review Oversight Committee if necessary, and the Scottish Ministers would retain the power to step in and overturn a decision not to carry out a review. In recognition of the need for transparency, ministerial oversight and ensuring that families are kept informed, Amendment 17 strengthens the documentation of decisions not to proceed to review. We have listened and learnt from the process currently operating in Northern Ireland. Having a clear audit trail that adequately captures the reasons for decision-making is clearly important and right. It also allows for further learning in terms of any issues or gaps in training. It could also inform enhancements to the statutory guidance. And in the same vein of transparency, Amendment 46 would expand the current requirement for a periodic report to detail reasons for the SIFT outcome under section 16(1)(b). This amendment will ensure the report also covers the reasons for a determination under section 16(1)(a) and that the committee is satisfied that a death is not reviewable. This will apply to both initial decisions and reconsiderations. Of course, I'll give way.
Maggie Chapman.
I thank the Cabinet Secretary for taking my intervention and apologies. I was waiting for an opportune moment to break her flow. Can I just check with the Cabinet Secretary, or can she confirm exactly what the process for ensuring families are kept appropriately informed of whether a review happens or not? Because that's not, and appropriately not set out very, very clearly in the amendments, but I think is really, really important as we understand keeping families up to date is. Thank you.
Cabinet Secretary.
Presiding Officer, I do very much endorse that view that at the very heart of practice needs to be keeping families affected informed, whether that's with a decision that a review will proceed or indeed if the decision is not. This, of course, will be a matter that will be very important for the statutory guidance that will be required to underpin practice and process, and I know that my officials have already begun those pivotal discussions with organisations representing victims and families. I'm not sure where I got to, Presiding Officer. Yeah, okay. I think I have finished, and I move Amendment 13.
Thank you, Cabinet Secretary. No other members are looking to participate. Therefore, unless there's anything the Cabinet Secretary wishes to add, the question is that Amendment 13 be agreed to. Are we all agreed? That is agreed. It takes us to Group 7, Part 2 reviews, the Police Investigations and Review Commissioner as a notifying body. I call Amendment 14 in the name of the Cabinet Secretary, group with amendments as shown in the groupings. Cabinet Secretary to move Amendment 14 and speak to all other amendments in the group.
Presiding Officer, my Amendment 14 would add the Police Investigations and Review Commissioner, the PIRC, as a notifying body under Section 14(5) of the Bill. This would require PIRC to notify the Review Oversight Committee of any death of which they are aware and believe to be a reviewable death. This is an important addition which responds to a request from PIRC directly that these should be included, whilst also recognising the unique nature of some of the cases the PIRC and staff deal with, which fall outside traditional notification routes. Since PIRC currently do not share details of these cases with Scottish ministers or the directing policing body during investigations, including PIRC within the bill, is necessary to ensure a clear and direct route for the deaths to be notified. This addition is also supported by Police Scotland, which has stated that it will help strengthen the review model. The inclusion of PIRC will trigger the need for changes elsewhere in the bill, so Amendments 19, 20, 21, 29, 40 and 53 ensure consistency across the bill and acknowledge PIRC's new role as a notifying body. These require PIRC to be a party to the protocol under Section 19 and subject to the duty to cooperate under Section 20. The PIRC office would also be added to the list in paragraph 3 of the schedule so that current and recent former commissioners and employees would not be able to apply for relevant offices under the bill, thereby avoiding conflicts of interest and helping to ensure independence within the review process. Various other minor consequential adjustments are also made. Finally, Amendments 15 and 16 make changes to Section 15(4) to provide that if one notifying body revokes its notification of a death as being reviewable but another has not, the review process under Section 16 still proceeds. This will ensure that we can account for the possibility of different views among notifying bodies and disapply in these circumstances the current requirement that any revocation of a notification halts further consideration of the death, and I move Amendment 14.
Thank you. Again, Cabinet Secretary, no other members are looking to contribute. If there is nothing further you wish to add, the question is that Amendment 14 be agreed to. Are we all agreed? Parliament is agreed. I call Amendments 15, 16, 17, 18, 19, 20, 21, 22 and 23, all in the name of the Cabinet Secretary, all previously debated. I invite the Cabinet Secretary to move Amendments 15 to 23 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 15 to 23? That no members object. The question is therefore that Amendment 15 to 23 be agreed. Are we all agreed? Yes. Parliament is agreed. Takes us to Group 8, Part 2 reviews, obtaining information about spent convictions. Call Amendment 24 in the name of the Cabinet Secretary, group with Amendments 27, 34 and 35. Cabinet Secretary to move Amendment 24 and speak to all amendments in the group.
Presiding Officer, following Stage 2 of the bill, the Scottish Courts and Tribunal Service highlighted a barrier in relation to the sharing of information for review purposes. The issue related to review panels not being able to access information about spent convictions and alternatives to prosecution. which may be pertinent in relation to individuals involved in the abuse that led to a reviewable death. Access to this information is important if we are to fully understand the circumstances surrounding such deaths. The Case Review Panel needs to be able to establish the whole relevant history, which may sometimes go back many years. The absence of that information would diminish the ability to learn from the full circumstances and apply the lessons going forward. Importantly, a case review panel is not determining anybody's legal rights and liabilities, so there is no direct impact on the person convicted from the information being disclosed to a review. Amendments 24, 27, 34 and 35 will operate in conjunction with secondary legislation which will be brought forward, specifically an affirmative order under the Rehabilitation of Offenders Act 1974. Together, these will enable this information about spent convictions to be obtained under Section 20 through the duty to cooperate provisions and Section 21 relating to the provision of information, notwithstanding the fact that they would not be admissible in evidence in court. And I move Amendment 24.
Thank you, Cabinet Secretary. No other member is looking to contribute. If there's nothing further you wish to add, the question is that Amendment 24 be agreed to. Are we all agreed? Parliament is agreed. I call Amendments 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36 and 37, all in the name of the Cabinet Secretary, all previously debated. Invite the Cabinet Secretary to move Amendments 25 to 37 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 25 to 37 en bloc? No member objects. The question is therefore that Amendments 25 to 37 be agreed. Are we all agreed? Parliament is agreed. It takes us to Group 9, Part 2 reviews, case review reports, sharing and anonymisation. I call Amendment 38 in the name of the Cabinet Secretary. Group with amendments as shown in the groupings. Cabinet Secretary to move Amendment 38 and speak to all amendments in the group. Cabinet Secretary.
Presiding Officer, my amendments in this group deal with two matters in relation to case review reports. As part of the review process, it is important that we are able to share reports with relevant bodies in confidence where relevant and appropriate. To ensure that is deliverable, Amendment 38 allows the Chair of the Review Oversight Committee and the Chair of the Case Review Panel to share draft review reports in confidence and in accordance with the protocol established under Section 19 with any person whom the Chair in question considers appropriate in order to check the accuracy of such reports prior to finalisation. The material can be redacted or anonymised as the person considers appropriate, and an extract from a report can be shared where that is all that is needed. At the same time as sharing it, the Chair in question must provide a copy of the material shared to the Scottish Ministers for information. This amendment will ensure the accuracy of reports, which is of course essential, and will allow for any necessary changes to be made in advance of finalisation. Amendment 42 will enable the Chair of the Review Oversight Committee and the Scottish Ministers to share approved review reports or parts of them with persons they deem appropriate. This is important in order to ensure lessons are shared appropriately, even if there are good reasons why the report cannot be published. If the review report includes unpublished material, sharing must follow the protocol established under Section 19, with options to redact or anonymise content, and recipients must keep such material confidential and not share it further. Any such sharing would therefore be done in a controlled and purposeful manner and could only be done in order to support learning aimed at safeguarding those affected by abusive domestic behaviour or promoting victims' well-being. Amendment 42 strengthens the learning and accountability framework while ensuring adherence to the established protocol and protecting the privacy of those involved. Presiding Officer, in relation to the matter of anonymisation in published reports, Amendments 40 and 41 are designed to strengthen the current safeguards. At present, the bill would prohibit the identification of any living individual in a published report unless they have consented to being identified. Following discussion with the Information Commissioner's Office and experts in the Information Governance Delivery Group as part of the Domestic Homicide and Suicide Review Task Force, it has become evident that relying on consent as a lawful basis for identifying individuals in published reports is problematic. My amendments remove the possibility of giving consent to being identified. They also modify the duty to prevent identification to one of taking all reasonable steps to prevent identification and extend protections to both living and deceased individuals. In addition, Amendment 41 will attach the anonymity requirement more specifically to those who need it. This has been done because now that with the exception for consent is being removed, a blanket approach to anonymity no longer works. A blanket approach would prevent, for example, panel members from being able to identify themselves as the authors in the report they produce, or prevent the citation of published author whose work has informed understanding of domestic abuse. The changes made by these amendments will ensure that review reports support learning and accountability without compromising privacy, safety or ethical standards. They also respond to concerns raised by the committee in its Stage 1 report and reflect the evolving understanding of information governance in sensitive contexts. In relation to deceased individuals, whilst data protection legislation only applies to the data of living individuals, there are strong ethical and practical reasons to treat the information of deceased persons with the same level of care in published reports as those living. This is why deceased individuals have been added under Amendment 41. In light of these changes, Amendment 40 will replace the current absolute duty in Section 22(9) with a duty to take all reasonable measures to ensure a person for whom anonymity is needed is not identifiable. This change acknowledges the unpredictable nature of indirect identification and aims to achieve a balance between transparency and privacy. Finally, the remaining amendments in this group are technical ones. They adjust the structure of the bill, splitting Section 22 into two in recognition of the extra material being added within it. And I move Amendment 38.
Thank you, Cabinet Secretary. No other member wishes to contribute unless there's anything further you wish to add. The question is that Amendment 38 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendments 39, 40, 41, 42, 43, 44, 45 and 46, all in the name of the Cabinet Secretary, all previously debated. I invite the Cabinet Secretary to move Amendments 39 to 46 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 39 to 46? No. 46. No member objects. Therefore, the question is that Amendments 39 to 46 be agreed. Are we all agreed? Yes. Parliament is agreed. It takes us to Group 10. Part 2 reviews, periodic reports. I call Amendment 47. In the name of the Cabinet Secretary, group with Amendment 49. Cabinet Secretary to move Amendment 47 and speak to both amendments in the group.
Presiding Officer, Amendment 49 will place a requirement on Scottish Ministers to consult with the Chair of the Review Oversight Committee, the Deputy Chair, the Case Review Panel Chairs and other persons as Ministers consider appropriate in the preparation of periodic reports. This will ensure that these periodic reports reflect the views of those operating the review model and is in response to the views of the Domestic Homicide and Suicide Review Task Force and stakeholders who want to ensure the independence of the process. Amendment 47 will broaden the information required to be included as part of the reporting requirements so that the periodic reports will be guaranteed to include the number of notices given by the Lord Advocate under Section 18 of the Bill, which is about pausing, discontinuing or resuming a review, and any reasons given under Section 18(3) in connection with those notices. This will provide further transparency about how the review process is operating, and I move Amendment 47.
Thank you. No other member wishes to contribute unless there's anything further you wish to add. Cabinet Secretary, the question is that Amendment 47 be agreed. Are we all agreed? Parliament is agreed. I call Amendment 48 in the name of the Cabinet Secretary, already debated with Amendment 14. Cabinet Secretary to move or not move?
Moved.
Question is that Amendment 48 be agreed to. Are we all agreed? Yes. That is agreed. I call Amendment 49 in the name of the Cabinet Secretary, already debated with Amendment 47. Cabinet Secretary to move formally.
Moved.
Question is that Amendment 49 be agreed to. Are we all agreed? Yes. That is agreed, taking us to Group 11, Part 2 Reviews Guidance. I call Amendment 50 in the name of the Cabinet Secretary in a group on its own. I invite the Cabinet Secretary to move and speak to Amendment 50. Cabinet Secretary.
Presiding Officer, Amendment 50 is a technical amendment that will ensure the Review Oversight Committee and any case review panel chairs appointed as part of the review infrastructure provide the Scottish Ministers with such assistance as they reasonably request in the preparation of guidance on the functions of the Review Oversight Committee and case review panels. This will ensure that the expertise and knowledge of the members of the Review Oversight Committee and that of case review panel chairs will inform the development and amendment of guidance, ensuring that it is always of the highest standards. And I move Amendment 50.
Okay, the question. I invite Eleanor Whittam to make a contribution.
Thank you very much. I was actually just going to intervene on the Cabinet Secretary to ask whether in the statutory guidance it could be made clear that victims' organisations such as Scottish Women's Aid and others will be represented within the panels and on the committee.
Cabinet Secretary.
Presiding Officer, my apologies to Ms Whittam for not catching her eye on the screen in front of me. Can I reassure her that my officials continue to meet with Scottish Women's Aid and most recently on the 26th of September, and it was around that very point about the importance of statutory guidance and ensuring that at all times we have the right people around the table to do the review so that we get the right learning. So I can give her that guarantee.
Thank you, Cabinet Secretary. Unless there's anything further you wish to add, the question is that Amendment 50 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendments 51, 52, 53, 54, 55, 56 and 57, all in the name of the Cabinet Secretary and all previously debated. I invite the Cabinet Secretary to move Amendments 51 to 57 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 51 to 57? No member objects. Therefore, the question is that Amendments 51 to 57 be agreed. Are we all agreed? That is agreed, and that concludes consideration of Stage 3 amendments. At this stage, as members will be aware, the Presiding Officer is required under standing orders to decide whether or not, in her view, any provision of the bill relates to a protected subject matter. That is, whether it modifies the electoral system and franchise for Scottish parliamentary elections. In the case of this bill, in the Presiding Officer's view, no provision of the Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill relates to a protected subject matter. Therefore, the bill does not require a supermajority to be passed at Stage 3. Before we move to the next item of business, there will be a brief pause.